everybody. Welcome back to Injustice for All with Judge Joe Brown. How are you, Judge?
I'll manage. It's not so cold today.
I know it's not so cold here in Ohio either. I'm happy. I don't know how long that's going to stay. So, all right.
By the way, the prognostication for what we're getting global warming is exceptionally warm winters with some very, very nasty, very cold snaps in the middle of it.
Oh, interesting.
That was predicted. I remember reading that Scientific American about 35 years ago.
Well, today we're not talking about the climate. We are talking about Trump, DOJ, civil rights, because recently, and I want to share this here, Department of Justice rule restores equal protection for all in civil rights enforcement. So on December the 9th, the Justice Department issued a final rule updating its regulations under Title VI of the Civil Rights 1964. This rule ensures that our nation's federal civil rights laws are firmly grounded in the principle of equal treatment under the law by eliminating disparate impact liability from its Title VI regulations. For decades, the Justice Department has issued disparate impact liability to undermine the constitutional principle that all Americans must be treated equally under the law. For decades, the Justice Department had issued disparate impact liability to undermine constitutional principle that all Americans must be treated equally under the law. No longer, this Department of Justice is eliminating its regulations that for far too long required recipients of federal funding to make decisions based on race.
Okay, let me explain what that is. I don't like this, but I said it was going to lead to this about 40 some years ago. Disparate treatment means this. If you take 100 employees and 75 of them get treated one way uniformly, and then 25 of them you look at, why did these get treated differently than the other 75? And then you look at them and say, oh, they're all Hispanic, or oh, wow, they're all Black, or wow, they're all Chinese or Asian. So, in other words, the disparate treatment is as a group with certain identifiable characteristics, this group gets treated differently than the others. Now, to fast forward up to the present, you saw this day before yesterday when we were reviewing the hearing with Fannie Willis. She kept saying, you're picking on me because I'm Black, and I should be given a Black female rather, and I should be given a break. So the disparate treatment would be, in this case, a reverse of what you would usually expect. And in other words, because she's a Black female, she shouldn't be held to the same standard as everybody else. That's disparate treatment. That kind of thing, pushed by the likes of her and the Democratic Party in policy for the last 30 years, has led to the principle of disparate treatment being an important factor in making a resolution. In other words, if everybody of one group is treated worse than everybody of another group, it's something's going wrong. But right now, it's been reversed. You saw Fannie Willis do that, where because you are of a certain group, you're supposed to be treated better. And that group usually was the one that used to be treated worse. Does that make sense?
No, it makes sense. And I'm actually going to go a little bit further when I bring up this next article, but I want to finish reading this from the DOJ.
All I was doing was just giving somebody context, because when you say terms like disparate treatment, what the hell does that mean?
Right. No, I totally get it. So she goes on to say the prior disparate impact regulations encouraged people to file lawsuits challenging racially neutral policies without evidence of intentional discrimination.
Fannie Willis the other day, but that was in a different context.
Our rejection of this theory will restore true equality under the law by requiring proof of actual discrimination rather than enforcing race or sex-based quotas or assumptions.
Okay, now how this whole thing started is 50 some years ago, 55, the U.S. Supreme Court said that you could use statistics to infer or prove issues in a case. And they would look at such things like, can you ask on an employment application if somebody's ever been arrested? Well, the rule from the U.S. Supreme Court 55 years ago was you cannot. Why? Because they found it was statistically impossible for a black man, not woman, but man, to reach 25 years of age in the United States and not to have been arrested at least once for no cause. So for ordinary employment purposes, without a demonstration of special need, what happens is you're limited to only asking if they've been convicted. Because at my age, there is no black man I know that has not been busted and taken to jail and then released with the charges dropped. And that's just universal. So that's the kind of thing they used to use, like asking on a job application if you've ever been arrested is discriminatory, or Title VII, because it discriminates against blacks because of the statistical impossibility of them having reached 25 years of age without having been arrested at least once for no good cause. So that's changed.
Mm-hmm. So it goes on to say for over 50 years, the prior disparate impact rule fostered that everything the Civil Rights Act of 1964 prohibited discriminated on the basis of race, color, or national origin. But with today's rule, the department reaffirms Congress' commitment to measure all Americans by merit. Congress enacted Title VI as part of the landmark Civil Rights Act 1964. It prohibits discrimination on the basis of race, color, and national origin in programs and activities. Receiving federal financial assistance. In 1973, the federal government added to the law a new rule, disparate impact. So that came about in 1973.
Yeah, I remember that. I was out of law school, and that was a hot topic. And I had the previous year worked in HUD, Housing and Urban Development, in the educational department, and they put me in a section where we compiled the statistics on what was going on in the educational institutions of the country.
Well, it goes on to say that was not part of the law. That's disparate impact.
That came from application of case law that the U.S. Supreme Court generated that was related, that went in. I just explained how that came about. Bondi may not be aware of it because she wasn't even born then.
And if she was a baby.
Yeah.
The term disparate impact refers to the concept of imposing liability on the federal fund recipient only because there may be different outcomes for different people, not based on prejudice or intent.
See, I know that the woke folk and the far left claims it's horrible, like it's always been. It's nothing like it used to be. You have no idea. We used to conduct studies, and we would take college students and we would match them up. Okay, what is your GPA? We check this. How old are you? Where were you born? What courses did you take? You're at college, you're a junior, one more year to go, you're a senior, you're getting ready to graduate. send everybody out to these various places and make an application for employment and let's see what came back. So we had some statisticians who would analyze this whole thing. I mean, it wasn't any lightweight stuff. And there were some statistically demonstrable outcomes that were across the board, where there was a 90+% probability on the outcome based on certain things and perceptions. Like we found that light-skinned black men were the worst when it came to employment success. Darker was better at that time. But on the other hand, for black women, the brighter you were, the better your prospects were. The prettier you were, your prospects were. There was no comparison between the employment prospects of black men and black women. Those of women were much better. In other words, we had a typical thing where out of the 25 businesses that we sent people into, there was almost a uniform rejection rate of all black males who may have had better GPAs, more applicable major to the particular job skill looked for. And we found that just about every single black male out of the 50 we had sent out to do this was rejected, but most of the black females were accepted, and those who were lighter or fairer skinned, high bright, had higher success than the darker ones.
That's true.
Yeah, we did that. That was in 1968, 69, and 70. We did this for 3 years.
Oh, honey, we're going to have to do a show on that.
See, I mean, it's not like that now. And like I said, in 1972, I was with HUD in D.C., where we were compounding statistics. And I talked about what these scoundrels did up at UC Berkeley, these Negroes who set up the Bakke case and reverse discrimination because they wanted it based on race, not merit. And it was a rule of 19 in all of California. This is the biggest state in the whole union with at that time, the best public education system in the world. And we had 19. We had 19 black dental students in all of California. We had 119 black medical students in the whole state and 219 black law students in the whole state. And we looked at those statistics, and when I was in D.C., since I already was privy to this, I was calling attention of the department to look at such things which they had not looked at before. Now, after you get these colored folk, Negroes, who were saying, well, those are political standards about what other merit you have in justifying someone's admission on the subjective criteria of other categories of admissions criteria that may have a bearing on their ability to succeed. That's a political test because you want these activist students. Well, yeah, we said, California Constitution said, basically, in modern terms, to maximize the fallout to the impacted community by who you select for certain universities in the state. So that's what we did, but they partied and got high and took long vacations because I had the money. And they were affluent, mom and dad. One was a dentist and one was a lawyer. The Cosby Show bunch, where one's a doctor and one's a lawyer. So that kind of thing, they didn't have any privation compared to the rest of the people that went into certain schools down in the hood or the barrio or something like that, or had an impoverished background. They lived in, the 4-bedroom house with a swimming pool, and they took vacations to Europe with their parents, and they didn't have the problems to overcome. So they collaborated with a student named Bakke, back in 1970, maybe 71. And what they did is they guaranteed Bakke would get a free ride, and they admitted all of these black students who didn't have anything except GPA, and they said they were the highest ranked blacks, but nothing else. And we had been advocating a competitive assessment of grade point average aptitude test and or other factors that indicated an ability to succeed. They had no other factors, so they wanted it based on race exclusively, which we said at the time was going to lead just where it has. It took 50 some years, but it got there.
To where we're at now today.
Yeah, and by the way, when Roberts wrote his decision, that all of the clown show folk out there are talking about, they overthrew affirmative act. No, what he did is, it's interesting. His decision is almost, as it's written, is almost word for word identical to the proposals that we put out for affirmative action back in the mid 60s. In fact, I helped write the one that they put in place at UCLA, which was one of the very first in America. And we said it should not be race based because that's insufficient. That will be defective. It will be attacked and destroyed if you go there. So what you do is just take objective criteria that, if they apply to anyone, would say overcoming this indicated a superior ability to succeed, and it indicates that the community this person came from needs somebody to come back who can help that community overcome its deficits. 9 times out of 10, if you draft it right, it would target a certain group, but you never said black, brown, red, yellow, preferred over white. You just said anybody, and that would include some poor white folk who came from Appalachia as well. And see, the whole idea is this. Look, gentlemen, if you guys don't understand what we're talking about here, it's 2:17 a.m. in the morning, and your airhead daughter, who will not look at the gas gauge, all of a sudden riding with her friend girl says, "Oh my God, look, we're about to run out of gas. Oh, we have to get off and get some." So they pull off of the freeway. And when they pull off of the Harbor Freeway, they're down in the hood. Now, do you want them to be at the gas station looking like, "Oh, please come rob, kidnap, or rape me, or do something nasty"? And everybody that is in charge in that area is a thug, a pimp, a drug dealer, or an armed robber, or some psychopath? Or do you want people who can help that neighborhood fit into the mainstream being the leaders?
Well,
Now,
let me finish going into
there
this.
you go.
It says one second. The prior disparate impact rule was already enjoined in one state, prohibiting DOJ from enforcing it there. The department's new rule reflects the best reading of Title VI, as the Supreme Court has repeatedly recognized for over 20 years. Title VI has and will continue to prohibit intentional discrimination. The department's new rule ensures that recipients of federal funding will be judged on their actual conduct, not on statistical outcomes or circumstances beyond their control. Despite decades of case law, the department's prior Title VI disparate impact regulations remained on the books, sowing confusion and creating costly compliance obligations from state, local governments, nonprofit, and private organizations receiving federal financial assistance. This new rule eliminates these burdens, promotes consistent enforcement across agencies, and restores public confidence in civil rights law by aligning the department's regulation with the Constitution.
Well, that's not out of line with what has become the de facto application of the law. As a reality, it's really kind of a mess, because over the years, and we heard that again with Fannie Willis talking about those ridiculous pay scales that she thought her underperforming staff should be paid, has become so prevalent in the legal profession that it is essentially priced out of reach of most anybody except the very wealthy or the corporate and business entities that are looking for deductions that, what with the impact on their taxes, actually are profitable to them. And it's almost impossible to prosecute a Title VII or VI case these days because you can't hire the legal expertise. You can't pay for the investigation. You can't handle the ongoing expenses. The time's too short. So you cut the single practitioner or the small office law office out of the picture because you need a big office to do everything that has to be done in 15 days, which most can't do because they are stretched pretty thin. And EEOC under Clarence Thomas got gutted, just gutted back in the 1980s. So it's no longer what it used to be. I used to work there 50 years ago. So the problem is what's going on right now is it's empty. And there are those who argue about the funding, and the Fannie Willises again who don't get it, that when state legislative bodies that have large rural elements, non-urban considerations, look very much askance at the urban entities and how they want to do things, and what they have as the way in, just like you saw, was we have a right to see how our money's being spent. So there is a pushback on it, and that was because of some selfish Negroes who wanted to get through medical school and didn't want to comply with the standards. They wanted special treatment, disparate treatment, based on the fact that they were Black rather than they had excellence.
Right. Well, I want to play this TikTok.
By the way, one little last thing. That came about because students back in the 60s were saying, look, you let these athletes in all the time. So why do you let them in when they don't have the technical standards on grade point average and aptitude test, either ACT or SAT? Well, they have indicated the ability to succeed because of what time they put into their athletics and the performance on the field. So they have maintained acceptable, if not the best, academics, along with this heavy burden of physical effort and concentration. And California's Constitution, 1851, says the same thing too. So that was already out there, but now they have corrupted that for personal reasons, just like you saw with Fannie Willis, where it's all about her. I, me, mine, Jasmine Crockett too. So it has nothing to do with the people. It's just an opportunity for the select few that can manipulate the system to get personal gain at the expense of somebody else. It's called reverse discrimination.
Are you all ready to go on the disparate impact rabbit hole with me? So we've been talking all about CFPB and their disparate impact proposed rule, but that is just the tip of the iceberg. Back in April, there was an executive order put forward that basically required the agencies to no longer enforce disparate impact. Now, executive orders are non-legal documents. Their agencies could technically ignore them. And by disparate impact, we mean unintentional harm caused to specific groups of people by policies that are being implemented by any federally funded organization. Last week, the DOJ said, we're no longer going to enforce disparate impact. And they didn't even do a public comment period. We've all been talking about CFPB's public comment period. DOJ just didn't even do it. They said they can just change it because it's an administrative internal policy. So now DOJ is saying they're only going to focus on cases with intentional explicit discrimination. And let's be real, this DOJ was never going to bring forward any of these disparate impact cases. But the fact that it's now an update to a 50-year-old policy that has held up under multiple Congresses and Supreme Court hearings is the thing that's disturbing. Individuals can still sue. That's fine. Go for it. But the DOJ is not going to be actively bringing cases on behalf of the government. And that's your disparate impact update. Are you all ready to go on the disparate impact rabbit hole with me?
That's bullshit. First off, she has no experience with the subject. Second thing, what's going on here is she's kind of got it in reverse. They didn't get involved in enforcing something that would end so-called disparate impact. What they wound up with was ignoring what became a disparate impact upon certain groups. Now, I bet you this woman has never suffered any discrimination in what's happened to her. But as I said before, you don't have anything out there with lawyer fees, court costs, and the huge amount of red tape that is now required to do anything in a federal court or a state court along these lines. So, and a confusing body of law that has been modified by do-gooders and folk that hate it, both. So it is overly complex, overly confusing, and it trips up even the best. So it's not a good thing. And what she's talking about is specious because she's thinking that the government got involved in going out and correcting wrongs. It didn't, because very little of that came to its attention. What they're talking about now is that her kind put in place a long-term series of decisions and situations so that disparate impact does not do anything other than what you saw with Fannie Willis. I'm black and I'm female, so I'm entitled to do things that other people are not do, and you should give me slack because I'm a poor black woman who, even though I lead a large district attorney's office, I don't need to know anything about the operation of my office, and everybody else does it. I'm a black female, so how can you hold me to a different standard than we expect? I mean, that's what you hold white men, and I guess maybe my predecessor, a black man, to, but I'm the first black female, so you have to give me some slack. You know, that's what they're talking about. That's a negative disparate impact.
Well, there
And by the way, disparate impact doesn't even come to the fore in American law with this. Where it comes into play, or it used to, was criminal law. In other words, the Supreme Court 50 some years ago said where there is a disparate impact in the prosecution, whether it's race-based or anything else, then you've got something to go on in terms of, hey, this is an improper prosecution. In other words, if what happens, let's say today, you look at a DA's office in a certain, let's say one of those parts of the country where they have the rainbows and everything, and you find that everybody who is everybody who is prosecuted is straight, heterosexual, male, and you don't see anybody else but that, although there are instances of, hey, you got this guy who is a known tranny and he's been in 5 times and nobody's done anything to him. So this is an accusation against this guy who is, say, a white college student or a black college student, both of whom are male. And they say something, they get jacked in, and somebody wants to put $150,000 bond on them, and they've never had a problem in their whole life before. And you say, wait a minute. Why are you treating this guy in a disparate fashion to way you treat these rainbow folk over here? You know, that's what you're getting right now.
Yeah.
So
Well, I wanna bring this into the conversation because you have former U.S. Justice Department staff. They're speaking out against this new rule, saying that they're actually destroying the Civil Rights Division. So it says more than 200 former employees at the United States Department of Justice have signed on an open letter decrying the destruction of the agency's Civil Rights Division under President Donald Trump. The letter published on Tuesday states that the Trump administration has turned the division's primary mission of defending civil rights upside down. Every election brought changes, but the fundamental mission of our work remained the same. That's why most of us plan to stay at the division following the 2024 election. But after witnessing this administration destroy much of our work, we made the heartbreaking decision to leave, along with hundreds of colleagues, including 75% of attorneys. Now we must sound the alarm about the near destruction of DOJ's once revered crown jewel. But after witnessing this administration destroy much of our work, we made the heartbreaking decision to leave, along with hundreds of colleagues, including about 75% attorneys. Now we must sound our alarm about the near destruction of the DOJ's once revered crown jewel. The Justice Department Civil Rights Division was created in 1957 in part to combat codified segregation and discrimination against Black people in the southern part of the U.S. during what was known as the Jim Crow era. The division has also investigated and penalized patterns of discriminations in such areas as housing, policing, and voting rights. But the Trump and his allies have often depicted efforts to address racial inequality as a sign of discrimination targeting white people. Tuesday letter from the Justice Department employees say the Civil Rights Division focus has shifted to issues aligned with Trump's own agenda. And that is what I want to bring to the fold, because Trump and his administration are saying that white people are being discriminated against. And that is what I will never agree on. White people, especially white men, but definitely white people have never been discriminated against in this country since the Mayflower.
All right. I think that's just bullshit. What's going on is, remember me talking about lawyers these days not going through internships equivalent to what the doctors are going through when they do internships, residencies, and so forth to learn what they're doing and transfer what they want to be from book learning to hands-on. Lawyers have the same kind of constraints. Now, in England, they've got to be at a house and go through an internship and a residency period before they're allowed to practice. But in America, they don't. So these lawyers, particularly the lawyers that are leaving, they just say, well, right now there is a call for, more lawyers, like we already don't have a glut. And that's because people are saying, I can't find a lawyer. And what they really mean is, I can't find anybody I can afford to pay, because these guys they have out there right now don't take many cases and they charge ridiculous fees for what they're doing. And the work product doesn't come out too well because they're too inexperienced. So we have served something of an internship. Now we want to move out in this lucrative private practice world, which they think is going to make fortunes for them. It might for a few, but that's like playing basketball. Very few get to be the superstar NBA player that they ideate about being. So same thing with lawyers. Now, this has not been a very effective thing for about 45 years. And that's how long it's been since you had an effective government involvement in these things. Most of the time, they're just collecting paychecks and it's just looking at contract compliance. So, as I said earlier, this crap that these far left people were doing, where everything's supposed to be like what we saw with Fannie Willis the other day. You get special slack cut to you because of what you are. Not you get put on an equal ground, you get an advantage. See, when we listened to Fannie, we were going, oh my goodness, what's wrong with that woman? What is she supposed to be doing? Well, you're just getting on me because I'm a black woman. And like, no, that we're getting on you or we don't like what we're listening to because you're not doing your job that you got elected to do and you're giving everybody a bad name. But you see, that's what the change has been. And this is some crap. See, I warned people years ago, decades ago, hey, look, if you don't stop this and get back to saying, okay, it's one thing when you talk about we want to end discrimination. It's a whole different order of business when you say you got to hire somebody because of their skin color without looking at competence. And you see that when you walk in a restaurant, a business, or anything, the people up in there, I don't care what their race or ethnicity is now, very seldom do you run into somebody that looks like they actually know what the hell they're doing. And the service is lousy. The product is lousy. We shipped everything overseas. You don't even have made in America in your kitchen drawers anymore. It says made in China because people have a better work ethic overseas. And it's time for somebody to put that back in place in this country where it's about excellence. That's like saying, hey, we don't have any white guys in the NBA playing on the court. So we need to hire at least 2 out of every 5 people on the starting team need to be white just because they're white. What can they shoot? I don't know, but we can get them out there so it looks good. Well, can they slam dunk? I don't know. We need some out there.
Okay, let me bring this into the fold here because his administration, the Trump administration, is actually encouraging white men and white people to file discrimination.
Yes, they should. No, because look, this is my specialty.
No. I want to play this video because this is Andrea Lucas. She is the EEOC chair, and I want to play this clip here.
I'm Andrea Lucas, chair of the U.S. Equal Employment Opportunity Commission. Are you a white male who's experienced discrimination at work based on your race or sex? You may have a claim to recover money under federal civil rights laws. Contact the EEOC as soon as possible. Time limits are typically strict for filing a claim. The EEOC is the federal agency charged with enforcing federal anti-discrimination law against businesses and other private sector employers. The EEOC is committed to identifying, attacking, and eliminating all forms of race and sex discrimination, including against white male applicants and employees. Check out EEOC.gov to learn more and read our one-page explainer about DEI-related discrimination.
I agree, they should, because somebody needs to even this mess out. In other words, what's happened is I'm a black male, and I can tell you from working at EEOC before she was born, it isn't the same now as it used to be. And one of the things that is bad is black men who were one of the people that were one of the ethnic status groups that was looked at and said, hey, they get a bad situation. We got a bad situation. Even the floor, even the playing field. So
you disagree, and I know this isn't just.
I mean, but I'm saying this. You know what this impacts? See, if white males are encouraged to do something about it, this bias against all males is brought into scrutiny. And right now in the employment place, it is very bad to be male.
They keep saying white. And the problem that I have, and the reason why I would never agree with none of that, white men are not being discriminated against. And if they are, show me the data. Show me those statistics. Show me. Now, you cannot sit up here and say you're eliminating DEI and you turn around and you're practicing it by specifically saying white men. That is a form of DEI. DEI has never said it's specifically for black people. So diversity doesn't just mean black. And I'm not done yet. Let me just get this out. White men have never been discriminated against in this country. I always say this. If you are a white man walking around here poor, homeless, or just a bum, that is a waste of whiteness. But now, I'm not saying the prior administration had a better idea, because the DEI came in under that whole initiative came in under the Biden administration. And that is just to give corporations millions of dollars to have these little BS programs. It wasn't to help Black people. However, when we are talking about white men being discriminated against, I want all you white people that agree with that, and whoever else agree with it, show me the data, show me the statistics that white men in 2025 are being discriminated against at a very high level to where they need to sue the federal government for retribution.
You're not getting it.
No, I do.
No, you're not. Let me give you what Thurgood Marshall said at a lecture I attended. This has been long time ago. He said the civil rights thing was brought about as a coalition between Jews and Negroes. He said, I added dogs to the mix. Said there were no laws that prevented cruelty to the Negroes. So my theory was, when I was practicing this civil rights law in the 30s and 40s, was if you couldn't do it to a dog, you couldn't do it to a Negro. The Jews funded us because if you couldn't do it to a Negro, you couldn't do it to a Jew. Now, right now, the most badly discriminated component in the American employment industry is the male, irrespective of ethnicity. So if you allow white males to stand in, that's very interesting, because tactically and strategically, they play the role of the Negro. In other words, if you couldn't do it to a Negro, you couldn't do it to a Jew. If you couldn't do it to a white man, you can't do it to a black one, red one, or yellow one. Why is that important? Right now, in the United States of America, the statistics have held pretty firm for the last 25 years. Each year, only 28% of each year's high school graduates are male. Only 32% of the college undergrads are male, and only 36% of the grad students are male. And worst off, only 44% of the American workforce is male. So that is preposterous. That is not the situation anywhere else in the world. So when you have 4 males to every 6 females in the marketplace, and contrary to the myth, the newly developing trend is that women are paid more for doing the same job than men are now. And there have been successful lawsuits about that around the country. Something's going wrong. So if you let white guys become the front, just like black guys used to be the front to protect the Jewish interest, you let the white guys be the front to protect masculine interest, because that 44%, 36, 32, and 28% is ridiculous.
The moment, it's a horrible tactic, because you sit up here, this administration, and you want to eliminate DEI, you want to eliminate race-based. Okay, fine. So why are you leading with race? White.
Well, here's the thing. In other words, I'm waiting for somebody to start a new trend, which is you're discriminated against because you're a straight heterosexual male. And they would win a lot if somebody was fair about the application. As things are right now, you have to encourage some people who are very angry about getting displaced. So motivate and give the opportunity to certain people who will actually go do something. See, a whole lot of people talk a good game, but they won't get out there and back it up. So if you take the white male population and say, we invite you to say you're being discriminated against in reverse, and it's provable. I mean, look at Fannie's staff.
So her office, she has white people, she has black, she has Asian. Now, if your hiring practices is, I only want black, I only want white, I only want an immigrant, yes, that is a form of discrimination. So what I'm saying is, if you Trump administration department heads and especially the lady that's in charge of the EEOC, if you could come out your mouth and say white men, you need to come and you need to file discrimination lawsuits, you are indeed practicing DEI. And on top of that, where is the proof that white men in America are being discriminated against? You don't have any proof.
Yes, you do.
There's no data. Show me.
Yeah, it is. I just cited it.
This is what
50% of the country, or 49.84 to 49.93% of the country's population is male. 28% of the high school graduates are male, 32% of the college students are male, 36% of the grad students are male, and only 44% of the workforce is male. Something's going wrong. That, by the way, is a disparate situation.
Thank you guys for tuning in to another episode of Injustice for All. And please put in the comment section below. I want you to drop some links and show me any stats and data of white men being discriminated against. So please share in the comment section your thoughts, or you can email it to me at danawiththedata@gmail.com. Bye.